Hi everyone. In this session, we'll be discussing about geographical indications. What are geographical indications? Geographical indications of goods are defined as that aspect of industrial property which refer to the geographical indication referring to a country or to a place situated therein as being the country or place of origin of that product. So, a geographical indication of good indicates or identifies the originating country or territory of that product, and this assures the quality and distinctiveness which is essentially attributable to the fact of its origin in that defined geographical locality, region, or country. For example, Aranmula Kannadi, Alapi Coir, Navara rice, Palakkad Matta rice, Malabar pepper, all these are attributed to a particular place. For example, Aramula Kannadi. The Aramula is a place, geographical indication. The same product may be manufactured and produced in a different places or different country, but that still have the name Aramula Kannadi because that shows the geographical indication. Same with Malabar pepper, Palakkad Matta rice, etc. So these are examples of geographical indications of goods from Kerala. Under Article 1, Clause 2 and Article 10 of the Paris Convention for the Protection of Industrial Property, that is Article 1, Clause 2 and Article 10 of the Paris Convention for the Protection of Industrial Property, geographical indications are covered as an element of intellectual property rights. They are also covered under Article 22 to 24 of trade-related aspects of intellectual property rights, or commonly known as TRIPS Agreement, which was part of the agreements concluding the Uruguay round of GATT negotiations. So, once again, Article 1, Clause 2 and Article 10 of Paris Convention for the Protection of Industrial Property, as well as Articles 22 to 24 of TRIPS Agreement, both discuss about geographical indications as an element of IPR. The TRIPS Agreement defines a geographical indication, commonly referred to as GIs, as indication which identify a good as originating in the territory of a member or a region or locality in that territory where a given quality, reputation, or other characteristics of the good is essentially attributable to its geographical origin. And that is Article 22 of TRIPS Agreement. India, as a member of the World Trade Organization, commonly known as WTO, enacted the Geographical Indication of Goods Registration and Protection Act 1999 and has come into force with effect from 15th September 2003. So the act, that is Geographical Indication of Goods Registration and Protection Act, came into being, was enacted in 1999 and it came into force from 15th September 2003. A geographical indication is owned by members of a community who produce the goods in question. A geographical indication acts as a mechanism that helps producers of goods and articles to differentiate their products from competing products in the market and enables producers to build a reputation and goodwill around their products that will fetch a premium price. The current international framework is laid down in Article 22 of TRIPS Agreement. It mandates member countries to provide for protection of all GIs. Thus, the member countries are bound to provide the legal means for interested parties to secure protection of their GIs, that is, geographical indications. Under Article 22, the scope of protection is composed of three aspects. 1. Protection against the use of indications that mislead the public or are deceptive. Now, the second one, protection against the use of indications in a manner that are acts of unfair competition. And the third one, refusal or invalidation of trademarks that contain or consist of indications where it may be misleading to the public. So the three aspects: one, where the indication mislead the public or are deceptive; the second, where the indication is used in such a manner as an act of unfair competition; and the third one, where it is used as refusal or invalidation of trademarks in order to mislead the public. Now, as a party to the TRIPS Agreement, India is required to protect GI, and hence, in order to fulfill that obligation, the Geographical Indication of Goods Registration and Protection Act 1999 was enacted and came into force on 15th September 2003. It may also be noted that India felt that some of its products have high potential to benefit from GI registration, and it was necessary to put in place a comprehensive legislation for registration and for providing adequate protection for GI. It is because unless a geographical indication is protected in the country of its origin, there is no requirement under the TRIPS Agreement for other countries to extend reciprocal protection. So, the geographical indication shall be protected in the country of its origin in order for the other countries to extend the protection. The main benefits which accrue from registration under the Act is: 1. It confers legal protection to geographical indication in India. The second one, it prevents unauthorized use of a registered geographical indication by others. And the third one, it enables seeking legal protection in other World Trade Organization member countries. From the perspective of a developing country, one of the best features of the Indian Act is the comprehensive definition given of geographical indication, whereby agricultural, natural, and manufactured goods all come under the ambit of geographical indication. This is especially important in the Indian context, considering the wide variety of goods that is deserving of protection, ranging from agricultural products like basmati rice, Darjeeling tea, to manufactured goods such as Banarasi sari, Kolhapur chappals, Chanderi silk, etc. Now, we discussed that it needs registration, and let's look into the registration process. So, the registration process has few steps. The first one is the filing of the application. Once the application is filed, there is preliminary scrutiny and examination, and then there is a show cause notice, that is if there is any objection raised or if there is any obstacles in signing the application, there is a show cause notice. Then once it is cleared, publication in the Geographical Indications Journal. Then opposition to registration. Once it is published, if there is any opposition, that can be raised. So opposition to registration, and finally registration. And once registration, it needs renewal after 10 years, and then there is also a provision for appeal. So towards this process, the first one, filing of application. Section 11 of the Act, that is Geographical Indication of Goods Registration and Protection Act 1999. The Section 11 of the Act discuss about that any association of persons, producers, organization or authority established by or under the law can apply for registration of a GI. The association of persons or producers or any organization or authority should represent the interest of producers of the concerned goods and should file an affidavit how the applicant claims to represent their interest. Application must be made in triplicate, that is, there should be 3 copies. The application shall be signed by the applicant or his agent and must be accompanied by a statement of case. Details of the special characteristics and how those standards are maintained are to be given. 3 certified copies of the map of the region to which the GI relates and the details of the inspection structure, if any, to regulate the use of GI in the territory to which it relates, and along with it you have to give the details of all the applicants together with address. All this should be included in the application. Now, if there's a large number of producers, a collective reference to all producers of goods may be made in the application and the GI, if registered, will be indicated accordingly in the register. Now, the applicant must have an address for service in India. Generally, application can be filed by a legal practitioner or a registered agent. Now, preliminary scrutiny or examination. Preliminary scrutiny and examination. The examiner will scrutinize the application for any deficiencies. The applicant should within 1 month of the communication in this regard remedy the same. So, if there is any correction to be made, the applicant should within 1 month of the communication shall make the changes or remedy the same. The content of the statement of case is assessed by a consultative group of experts well versed on the subject. They will ascertain the correctness of particulars furnished. Thereafter, an examination report would be issued. Now, the third stage is the show cause notice. If the registrar has any objection to the application, he will communicate such objection. The applicant must respond within 2 months. So, if there is an objection from the registrar, the show cause notice shall be given within 2 months or apply for a hearing. The decision, whether accepted or rejected, will be duly communicated. If the applicant wishes to appeal, he may, within 1 month, make a request. The registrar is also empowered to withdraw an acceptance if it is accepted in error after giving an opportunity of being heard. So, the show cause notice shall be within 2 months, or the applicant can apply for a hearing, and if there is any appeal, that should be made within 1 month. Now, the next stage is publication in Geographical Indications Journal. Every application within 3 months of acceptance shall be published in the Geographical Indication Journal. So, that is, if the application is accepted by the registrar within 3 months, it shall be published in the Geographical Indications Journal. Now, opposition to registration. Any person can file a notice of opposition within 3 months, and this may be extended by 1 more month if it is requested and has to be filed before 3 months. That is, by default, only 3 months is given to file an opposition. Within this 3 months, if a person makes an application for extending the time may be extended to up to 1 month, further 1 month, but the application for extension has to be made within the initial 3 months. Now, opposing the notice of opposition opposing the GI application is published in the journal. The registrar shall serve a copy of the notice to the applicant, that is the applicant of the GI. Within 2 months, the applicant shall send a copy of counter statement. That is the same time period as in the objection show cause notice, where the registrar has raised an objection. Here also the time limit is 2 months. Within 2 months, the applicant shall send a copy of the counter statement. If he does not do this, he shall be deemed to have abandoned his application. So, if a counter statement is not made within 2 months, it shall be deemed that the applicant has abandoned his application. Where the counter statement has been filed, the registrar shall serve a copy on the person giving the notice of opposition. Therefore, both sides will lead their respective evidences by way of affidavit and supporting documents. A date for hearing of the case will be fixed thereafter. Now, once all the opposition obstacles all are remedied, then comes registration. Where an application for GI has been accepted, the registrar shall register the geographical indication. If registered, the date of filing of the application shall be deemed to be the date of registration. So, if registered, the date of filing of the application shall be deemed to be the date of registration. So, it is the date of filing of the application that is deemed as the date of registration. The registrar shall issue to the applicant a certificate with the seal of the Geographical Indication Registry. Now, once it is registered, after 10 years, we need to renew it. That is, a registered renewal, a registered geographical indication shall be valid for 10 years and can be renewed on payment of renewal fee. And earlier we discussed about appeal. So, any person aggrieved by an order or decision may prefer an appeal to the Intellectual Property Appellate Board IPAB within 3 months. Now, what kind of indications are not registered, which cannot be registered? That is, indications that cannot be registered. So, under the Act, agricultural, natural or manufactured goods originating or manufactured in the territory of a country or a region or locality in that territory where a given quality, reputation or other characteristics of such goods is essentially attributable to its geographical origin, and in cases where such goods are manufactured goods, one of the activities of either production or of processing or preparation of the goods concerned takes place in such territory, region or locality are registrable in geographical indication. So, it can be agricultural, natural or manufactured goods originating from a country. And why do we register it? That is, the quality, reputation or other characteristics of such good shall be dependent on that geographical origin, that is the country, territory or locality. Such indications can be registered. Now, Section 9 of the Act prohibits registration of a geographical indication under some circumstances. For example, 1. The use of which would be likely to deceive or cause confusion. 2. The use of which would be contrary to any law for the time being in force. 3. Which comprises or contains scandalous or obscene matter. 4. Which comprises or contains any matter likely to hurt the religious susceptibilities of any class or section of the citizens of India. 5. Which would otherwise be disentitled to protection in a court. 6. Which are determined to be generic names or indications of goods and are therefore not ceased to be protected in their country of origin or which have fallen into disuse in that country. 7. Which, although literally true as to the territory, region or locality in which the goods originate, but falsely represent to the person that the goods originate in another territory, region or locality as the case may be. So, these are where the geographical indication prohibits registration. that is discussed in section 9. Now section 25 of the Act, by prohibiting the registration of a geographical indication as a trademark, tries to prevent appropriation of a public property in the nature of a geographical indication by an individual as a trademark, leading to confusion in the market. Now, according to section 24 of the Act, a geographical indication cannot be assigned or transmitted. So this is very important. According to section 24, a geographical indication cannot be assigned or transmitted. The Act recognizes that a geographical indication is a public property belonging to the producers of the goods concerned, and as such, it cannot be the subject matter of assignment, transmission, licensing, pledge, mortgage, or any contract for transferring the ownership or possession. So what is not allowed? Assignment, transmission, licensing, pledge, mortgage, or any contract for transferring the ownership or possession of that geographical indication. Since the first Indian geographical indication, and that was Darjeeling Tea, was registered in 2004, 236 geographical indications have been registered with the Geographical Indication Registry of India. Aramola Kannadi was registered in the year 2004 from Kerala. Malabar pepper, Palakkad and Matta rice, Alapi coir, Navara rice are other products registered from Kerala. Now, there is a question: how is geographical indications distinct from appellation of origin? A geographical indication is a sign used on goods that have a specific geographical origin and possess qualities or a reputation that are due to the place of origin. So all these are due to the place of origin. Geographical indications may be not only place names but also other names and indicators used to refer to a product. On the other hand, an appellation of origin is a special kind of geographical indication. So an appellation of origin is also a geographical indication, but it is a special kind of geographical indication used on products that have a specific quality that is exclusively or essentially due to the geographical environment in which the products are produced. Agriculture products typically have qualities that derive from their place of production and are influenced by specific local factors such as climate and soil. Thus, the concept of appellation of origin is subsumed in that of geographical indication. So that is with geographical indication and what can be brought registered under geographical indication, and what are the prohibitions, and what is the distinction between geographical indication and appellations of origin, and why there is a need for registration of geographical indication. So that is with this session. I hope it helps. Thank you for listening. Thank you for your support. Please like the video if you liked it, and if you are not subscribed it, please subscribe to my channel to support me. Thank you. Have a nice day.